Good morning, everybody. Thanks for joining us again. Just to reiterate what Megan said, my name is Matt Danner. I'm the CEO of Monolith Forensics. And just a quick, if you're not familiar with, I think most of you guys are familiar with us already, but if you're new, if you're not familiar with the company, Monolith is a software company that builds software for digital forensics, cybersecurity, and e-discovery teams and companies. And we just sell one product. The product is called Monolith. It's basically a case management, evidence management, operations management system for digital forensics teams. So if you're in need of something like that, or have any interest in it, or if you just want to, support us doing these sort of technical webinars, just check out our website. We have some free tools on there that you can download and use if you want, and you can also check out the feature set of Monolith. And if you're interested in trying it out, just reach out to us, and we'll be happy to set up a demo or get you access to a trial of the software. Okay, so for this presentation this week, I'm going to cover something called forensic protocols. So the term forensic protocol, it sounds pretty generic, but I'm actually referring to something very specific in forensic work. And for those of you guys that are in law enforcement, you probably aren't super familiar with this topic, but it's something that we use a lot in private sector digital forensics, especially with relation to civil litigation. So what I'm going to do is I'm going to start by sharing my screen because I have an example template forensic protocol pulled up that I can use as sort of a rubric to go through as I'm talking about this topic. Okay, let me make sure I'm sharing the right thing here. Microsoft Word, perfect. Okay, so you should be able to see a Microsoft Word document on the screen. And Megan, let me know if it's zoomed in far enough so that people can actually read it and see it. Let me kind of explain and set the stage here for what a forensic protocol is. So typically in a lot of civil litigation work related to digital forensics and e-discovery, a forensic protocol is something that's pretty common that's used the best way to describe it is basically some kind of document that just outlines the forensic work that's going to be conducted by the forensic examiner or a team of forensic examiners. And the main purpose behind it is so that if you're in an adversarial litigation where you've got a plaintiff and a defendant, and you've got some digital evidence or data that's at the center of that litigation, you got parties that want access to data, you got parties that want to protect data, you've also got relevancy issues in terms of what data needs to be provided that's actually relevant to the case. And what a forensic protocol does is just adds some defined structure to the work that we're actually going to conduct as forensic examiners or forensic experts. And what the protocol does is it allows us to write down the processes, procedures, and actual steps we're going to take so that both parties have something to review and negotiate around and agree to and put in place so that everybody is happy with the process that's going to occur. The reason this is needed in a lot of cases, because frankly, there's a couple of reasons, but for one, it's a big help to both parties, the attorneys on both sides, where they're not forensic experts. So they don't know the things that we are capable of doing all the time. They don't know exactly what we can do, what we can't do. And so when somebody like us gets hired to help in these cases, a lot of attorneys are just really unsure about what the work is actually going to be and what it's going to look like when we do it. They have no idea what our processes are. They have no idea how we're going to search through and segregate data and that sort of thing. So the forensic protocol gives them it gives them a legend or a rubric to use to understand how we're actually going to conduct the work we're going to conduct. And it also gives them some peace of mind to say, okay, this is the standard and the steps and processes through which the forensic experts are going to be held accountable. So it basically gives them some peace of mind to say, okay, now I understand exactly how my client's data is going to be reviewed. I understand exactly how my client's data is going to be processed and produced. It gives them basically a strong sense of how to understand the forensic process and how their client's data is going to be managed. It also is there just to provide sometimes in these adversarial cases, the attorneys on either side can kind of sort of be sort of fighting each other in the dark a little bit over digital evidence because neither side really understands, doesn't that necessarily always have a full in-depth understanding of how digital evidence works and how digital evidence processing works. So sometimes attorneys on both sides can sort of argue with each other and be negotiating on things they don't fully understand. And what I found in my career, at least with cases like this, the forensic protocol really, really helps that by it just gets everybody on the same page. It gets everybody on the same page, gets everybody working with the same information, with the same processes so that they're not kind of just stabbing each other in the dark. And I found too, this is really helpful when I've worked on cases where at this part of the case, I might be the only forensic expert engaged on the entire case so far. Like the other side hasn't engaged a forensic expert yet. And the other side is considering like, okay, do we need to pull in our own expert to help with this? And what I found is sometimes when I propose something like a forensic protocol, or if I put a rough draft together for a protocol and we pass to the other side, it actually smooths out the process and makes things easier because now the other side becomes a little bit more receptive to just having just me do the work because they now have a legend or a process map that they can hold me accountable to. So if we do something out of line or if I step outside the parameters of the forensic protocol, it gives them a way to hold the side that I'm working for accountable or hold me accountable specifically. So it just alleviates the pressure that the other side needs to get their own expert. Now that doesn't mean I'm saying I'm trying to convince them not to, but I personally don't care if another expert gets involved in a case on the opposing side. But what I do care about a lot of times is when we do this work, it can sometimes be frustrating for me and for people that are doing this work that the two sides just can't simply agree to a process that they want to execute. And to me, that's the most frustrating part where it's like, we're ready to do the work. We're ready to get down to business and start getting this data processed. But we get put in this holding pattern and we end up having to field tons of questions about the data and how the data lives, how it exists, how it's going to be collected, how it's going to be processed, all the different areas of the data and how it could live and exist. And you end up going in circles and circles with both sides just arguing and negotiating around how we're going to do this. The forensic protocol it just adds a nice layer to helping that process along and getting things moving. And sometimes what can happen is if the other side is busy trying to decide if they want their own experts, it can just really slow and grind everything down because now they have to go through the process of deciding if they want another expert. Then they have to go find an expert, engage them, hire them. And now we've got two sets of forensic experts that are in the process of negotiating this whole situation. And that just makes things more complicated. So the conclusion here is these forensic protocols are basically, it just adds a lot of structure to this process of handling digital evidence in an adversarial situation like civil litigation. Now, the other thing I'll say too is I'm talking about forensic protocols in the scope of civil litigation, but really there's nothing magical about forensic protocols where they need to be used just in civil cases. These can be used in any context in which you're doing digital forensics. It's just a matter of whether you think it's a good thing to use. So to my knowledge, I don't believe this has ever been something that's really been used in criminal cases, but there's no reason that it couldn't be used. I think the reason it's not is because most of the time, if you're in law enforcement, you'll get a search warrant, and that search warrant just gives you, depending on how it's worded, it just gives you a lot of flexibility and a lot of freedom in terms of how you look at and review data. So sometimes a forensic protocol isn't really necessary, but you could see situations where if you're in law enforcement, and let's say that you have a case that you worked on and it's now being adjudicated through the courts and the other side hires a defense expert. Well, maybe you would like to have a forensic protocol in place that outlines, some of the basic rules and standards that you want around that expert reviewing that evidence. So, for example, if you have a case related to child sex abuse material and you want to make sure that there's some parameters around how the defense expert is going to access and review that material, something like a forensic protocol might be really helpful because you can literally just write down and outline the process for how you like defense experts to access this material and do the review. You can lay it out in a nice professional forensic protocol and just provide that to defense counsel, provide that to the court. It doesn't mean they're going to follow it. That doesn't mean they have to follow it. This isn't a binding document. It just means that you're providing some defined structure that everybody can review and ingest and agree to. including the court and the judge if there's some kind of issue around access to the evidence. So the whole purpose is that these protocols just provide a mechanism through which everybody can start progressing towards a resolution on handling, reviewing, collecting, processing digital evidence. So a couple of things. So this template, and I don't mind sharing this template with you guys. This is sort of a maximum damage template, meaning it just kind of covers every single nook and cranny that you would want in a forensic protocol. But it by all means does not have to be this extensive. And also this is sort of covering a very common case type in private consulting digital forensics, which is what I would refer to as a remediation case, which basically refers to you'll get cases if you work in the private sector. You get these cases from time to time where a typical scenario is an employee leaves one employer to go work for someone else, and that employee has some previous company data on their laptop, their personal laptop, or their phone, or maybe they have some stuff in Google Drive or whatever. And the former company learns about it and isn't happy about it, and they want to start, they want something to be done about it. They want that former employee to go through a process to basically identify and remove or return that data to their previous employer. And so typically when those things happen, sometimes depending on the case, we'll implement and put together an actual forensic protocol that both sides do agree to. That same type of case, though, sometimes we don't do a protocol. Sometimes it's very straightforward. They just have a few documents in Google Drive or something, and it just becomes a matter of going into that, collecting that person's drive, identifying the files, and then just deleting them from the account and then providing a report that it happened. It just depends on the case, but in more extensive cases where there's lots of litigation or lots of accounts and devices and lots of data at hand, a forensic protocol is often used to help lay out that entire process so that we can execute on it confidently. Having said that, you can put forensic protocols together for literally anything. Any forensic process you want to do, you can design a forensic protocol around it. All the protocol is doing is just literally laying out the steps that you're going to take to execute a forensic process. That's it. So it can literally be for anything. It can be, I've done protocols for this remediation work where we're just identifying and removing data from a person's devices and accounts. I've also done protocols around just search protocols, just being able to execute a certain type of searching across emails or searching across documents, where the protocol outlines search terms and search methodology, things like that. I've done protocols around analysis where the protocol has outlined a specific type of analysis we're going to do on data, given certain parameters like date ranges or data types or the types of data we're going to conduct analysis on, the types of data that it has to be excluded from the analysis. So I've done protocols for all this different stuff. And again, it just comes back to designing it and putting in the processes that we're going to follow. The thing I would recommend for this too is a lot of times attorneys will draft these protocols. So they'll sometimes draft it. And what I would say is, in most cases, the attorney might draft something and then pass it to me to review as the expert and give him some feedback on, okay, here's what's going to work. Here's what's not going to work. Here's some caveats or whatever. Here's some stuff you didn't think about. But every once in a while, an attorney will put one of these together and not include you in the discussion and just agree to something that the other attorney also agrees to before you've even had a chance to look at it. In worst case scenarios, sometimes the judge will even sign off on it and put it and file it into some kind of order that they put together. That can be really challenging because sometimes they will put together a protocol with things in it that don't make any sense or things that have been completely missed. So what you want to do is when you work if you're in the private sector and you're working with lots of attorneys and clients, when you are doing work with them and you bring up the concept of forensic protocols, you want to make sure they understand, like, here's the basics of the protocol and what should go into it, and that make it very clear to them that whenever they put a protocol in practice or if they receive one from the other side, they should have you or someone with your expertise review it first. So make sure there's no gotchas, make sure there's nothing that's missing, make sure that it's covering all the things that you need to cover, and also to make sure that any specific steps or processes outlined actually makes sense and are actually something you're comfortable with doing and being, because you're going to be the one held accountable to it. If you color outside the lines on these things or you do something you're not supposed to, you're going to be the one that's going to be held accountable to those processes. So you just want to make sure it's something you're comfortable with doing. So if we walk through this protocol really quick, we have some basic things here. Like like I said, this is a very extensive protocol. This covers a lot of ground. Your protocols that you put together do not have to be this extensive, but this is just here so that it's a catch-all for pretty much everything, and then you can edit this down or do anything else you want with it. But basically, we have here, the top here is just a summary of what this protocol is, what it's for, the case it's related to, the clients involved, purpose. This is identifying the main purpose of this particular protocol. So depending on the issue at hand that's being resolved, you want to describe why we're even doing this protocol, why it's even in place. We have a section here that just discusses who is going to be completing the protocol. And I even have things in here like there's some references to SWGD, NIST, and ISO. You don't necessarily have to be that specific if you don't want. And you could just remove those just so that, if you don't want anybody to necessarily ask you about, well, what standards in SWGD did you use? What standards in NIST did you use? If you want it to be a little bit more flexible, you can just remove those references and just say, consistent with, typical or standard practices in the forensics industry. And basically, you have stuff here about the examiner is going to execute an engagement as a neutral. Sometimes you're not actually doing this as a neutral. You could be a neutral, but sometimes you're doing it, where you are just hired by one side, but the other side has just agreed to let you execute the protocol. So you're not always neutral, but sometimes you are. So it can be good to, if you are acting as a neutral, it can be good to state that in the protocol just to make it clear. There's stuff here about liability insurance, which honestly, we don't normally add this, but again, this is just, you can add it if you want, especially if you're putting in place a protocol for another expert to execute. Maybe you're not the one doing the protocol, but you're putting one together to propose to the other side that their expert execute. So there could be things like this that you put in place. And here we have some definitions here. So this is a big one right here. Defining the data sources in these cases. So this is a very generic list where this is kind of a kitchen sink style list of all the data that could be at issue here. Like I said, in this particular forensic protocol template, this is taking a kitchen sink approach. So it's just kind of listing any and everything they could think of. In some cases, this is what you have to do because you don't necessarily know when you're putting this protocol together, you may not even know what devices or accounts may be at issue yet. That's part of like the engagement in the case is that you're going to use this protocol to try to investigate what devices and accounts are even at issue. But a lot of times you may actually know the specific devices or accounts that are at play in these cases. So you can actually specifically define the accounts and devices that you want the protocol to apply to. But a lot of times you don't have that information yet. So depending on how extensive the attorneys want you to go, you can have general language like this that just covers like basically any and all types of data sources that need to be a part of this protocol. And then we have some additional definitions here that just identify different dimensions of the protocol, things like what property means. What do we mean by property in this context? What do we mean by personal property? What is a forensic image? What does attorney's eyes only mean? These are all things that are going to be, these are all terms that we're going to be using throughout the protocol. And it's good to just define these so that everybody understands what we mean when we use these different terms. There's a section here on preservation obligations, which this doesn't have to be a part of the protocol because typically this is part of the legal process. When when a lawsuit is filed, there's usually notices of preservation sent out. And this is just kind of, again, this template is taking a kitchen sink approach. So we're just sort of identifying preservation obligations from a forensic point of view. Like, hey, this is what we mean when we say preserve. We're saying don't do these things, or here are some things you can do to, prevent potential data loss, even inadvertently. But again, this is extra. You don't necessarily have to add this, and the attorney may actually have you remove it because they don't want you to necessarily be the one defining what preservation means. And so this section here, this is also, this right here is probably the most important part of the entire protocol, is whenever you're executing on these types of protocols, especially something like a remediation or something like that, it's incredibly important that you have a step where you work with the person who owns these devices and accounts, and you just create an inventory of all the devices and accounts that need to be examined. Without this step, this whole process, most of these processes that forensic protocols are based on, is just going to be a huge pain in the ass, because you're going to be constantly dealing with not knowing what accounts exist, not knowing what devices are out there. You're going to get you're going to get information piecemeal to you about devices and accounts. And it's really hard for you to do the rest of your work if you don't have a good idea of the universe of devices and accounts that are at play. This is also important too, because once the all devices and accounts that could potentially be at play here are identified, again, it gives both sides an opportunity to negotiate around or debate around which devices and accounts actually matter and which ones are relevant, right? So then that means things like you might have a person that identifies every computer in their house. They might have a personal like family computer. They might have a personal laptop that only they use. They may also have I've had cases where the defendant or the person at issue, they had a laptop at one time that they used for work and personal stuff, and then they gave it to their daughter or their son for them to use, and then they bought themselves a new laptop. And now you have this problem of like, well, that laptop's only being used by the child, but the dad or whoever maybe didn't go through any process to delete any data from it or factory reset it or anything like that. So there's a question of like, even though this is the child's device now, like there could still be data on there that's relevant to this case. So you have situations like that where you need to identify those things and then have that conversation with the parties to understand like, okay, do we actually need to look at this? Like, what's the likelihood this thing's going to have responsive data on it or data that we care about? And if you don't take this step here to inventory all the possible data sources and devices, you can't have that discussion. And what can happen is you'll be 5 steps deep into this protocol, and then suddenly someone will realize, oh crap, there's this laptop that my daughter's using that I forgot had had a bunch of work stuff on it. And now you have to like retrace and go back to step 2 and start the process all over again for that device. So you really want to, this is probably the most important step of this entire process, is just simply identifying all the devices and accounts that could potentially be responsive to this protocol. And then decide from there, once you have that list, then you decide which devices are relevant, which ones are going to apply. And that way, there is no mystery. There aren't any surprise devices or accounts later. And you can just confidently move forward in the protocol. So this section here is just covering, this is the process through which you as the examiner are actually going to receive the devices and access to the accounts. So this is just outlining, okay, at this date and time, and again, some protocols will actually state the timeline of like when these things are to be completed. That's pretty common. Sometimes they don't. It just depends on how the protocol is being put together. But this section just outlines like, okay, here's what we're going to do. Here's how we're going to actually collect and get access to physical devices like phones and laptops. Here's what we're going to do to get access to cloud-based accounts like Gmail or Google Drive or whatever. And sometimes, if you'll notice here, this is describing a pretty general collection process, but you can also go into specifics. You can specifically state the exact method you're going to use to image and collect devices and accounts if you want to. I would shy away from that if possible, because you want to have the flexibility to use different methods. If your primary collection method is failing for some reason, you want the freedom or the flexibility to be able to switch to a different method. So you want to keep it fairly general, but if you wanted to, you can get as specific as you want and literally outline the exact collection process you're going to use for each data source. This is another pretty common section where it's just defining how, like, okay, great, we have this data collected. Now, how are we going to identify out of this data we've collected, what process are we going to use to identify responsive data that matters in this case? And so typically you can see here, it's giving a pretty generic description of like, hey, we're going to use date ranges. We're going to use search terms. We're going to use these different scoping methods and categories. In this protocol, it's outlined pretty generically. And it's just saying that external to this protocol, these things are going to be defined by the parties and agreed to, which is definitely something that happens from time to time. You'll have the generic protocol, and then the parties will, outside the protocol, define a set of parameters and search terms to use during your review. Also, though, a lot of times those parameters and searches will be baked right into the protocol. So like things like search terms, date ranges, categories of data. So they might say, yeah, you need to search these search terms and within this date range, but only search like PDFs and Word documents. Like we don't care about anything else. Or only search the user's profile folder on Windows. Don't include the app data folder, for example. Like there's certain parameters like that that may be put into the protocol where you're given very specific instructions on how to conduct your search and what data to review. So again, it just depends on the protocol. Sometimes it's very generic like this, where you get the parameters outside the protocol, but sometimes the parameters are baked directly into the protocol, so that you have a specific series of terms and things to search for. The other thing I'll say on this too, I don't think it's in here because this is more of a remediation protocol, but for cases that for protocols where the protocol is focused on some kind of analysis that you're going to conduct, you'll have a similar section to this that is actually going to outline the specific analysis that you're going to do. So again, like this, it might be generic where it will say, the examiner shall conduct analysis on the following types of data for the following purposes. And it might outline specific things like the examiner will review web history on this device for anything that relates to the following types of content. And it might list the types of content that you're going to be looking for or the date ranges of web history you're looking for. And it may literally go through that. I've seen protocols where, the device that'll be examined is a Windows computer, and the protocol will literally outline all the different forensic artifacts on Windows that we're going to examine. It'll list things like registry, shell bags, shim cache, link files, event logs. Like it'll specifically outline the exact artifacts that we're going to be looking at for the analysis and the types of and like basically what are we looking for in that analysis? What things are we actually checking for? You'll also see this on phone cases. So in things like if you ever work like a personal injury case with like a car accident or a trucking accident, something like that. This is also pretty common on mobile device examinations, where it will outline some specific things to look for in your analysis when you're doing a forensic examination of a mobile device like an Android or an iPhone. And it will specifically outline things like date ranges and the types of data that you're allowed to do your analysis on the phone. But again, that's, like I said earlier, these protocols can be used for any forensic process at all. So this one in particular just happens to be focused on like the remediation process, but you can also have one that's more focused on like the forensic analysis process as well. This next section here, this is also a very common section where there's always going to be some discussion about privileged and private information on the phone. And typically the way this will work is the attorneys will, just like search terms, things like that, they will define a list of parameters or standards that they think would allow them to tag certain data or types of data as privileged or private information. And so what we mean by privileged is we basically mean attorney-client communications and other types of privileged or confidential communications that are exempt from this process. Protected materials usually refers to either private information that's irrelevant, so things like the user's personal data that has nothing to do with the case, or even confidential data that may be owned by a third party. So, for example, sometimes you might get a case where an employee has gone to a different employer. They now have a work laptop at that employer, and that new work laptop may become a part of this protocol, of this process. And so you have this whole other issue where now you've got another third party involved that may have their own confidential data that could be exposed in the examination. So now there's this whole set of parameters you need to consider when doing your search, where if your search results in any of these items that belong to that third party that has nothing to do with the case, you now have to have a process to exclude those items and document why they're excluded. So that's what this privileged and protected materials clause does, is it outlines like, okay, here are all the ways in which this search may result in private, confidential, or privileged data that should be exempt. And here are the parameters we're going to use to identify those things. And on top of that, when they're identified, we're going to create some kind of privilege log that identifies all these things that we've excluded, that maybe we had search hits on, but we also identified as private, privileged, or confidential. And now we have this log of items that we've excluded, so that if the attorneys have some disagreement over whether they should be excluded or not, you now have a list, and this gets into the weeds a little bit, but sometimes like even the judge will have to do what's called an in-camera review and review the privilege log stuff and make a determination as to whether parts of it are not private or privileged and that sort of thing. So again, this whole section outlines like the process under which you're going to execute identifying privileged and protected materials. This is a review and designation piece. So this again is just this is identifying the process through which you're actually going to tag and identify search hits and things that are responsive to the process and the protocol. Again, there's stuff that comes into play like attorney's eyes only, things like that. There's going to be rules around how to share this data and that sort of thing. So this is more outlining how the attorneys are going to handle the relevant results that you get. It's just outlining how the attorneys are going to potentially review and produce this stuff. This becomes very, very variable because sometimes you'll have a sort of weird process where you conduct your searching, you identify your search hits, and you get some results. And the protocol may state something like, okay, you are the first place that gets to review the results are going to be the client, the owner of the data, and their attorneys. They get first pass to look at it first. They look at it, and then they go through a process where they identify anything that they think is either private, privileged, or irrelevant that wasn't already caught in the privileged review, their privileged screen. And then once they do that, they will then create their own privilege log. And then we get back the data, and sometimes you're asked to redact the items that they've tagged as private and privileged. And once that happens, then you provide that final set to the other side for them to review. So there's this whole like sort of back and forth that may happen in the protocol. Sometimes the protocols are a lot simpler where it just simply says, hey, you do your searches, you get your results, and then you just provide them to both parties at the same time. And then the parties deal with like any private privileged issues on their own. Sometimes it's that simple, sometimes it's much more of a back and forth process. And this section here just outlines the steps through which that process is going to proceed. Finally, we get to like this step in this particular protocol, which is the remediation step. And this right here is just outlining exactly, so okay, we've collected the devices, we've done our searches, we have our search hits, we've identified all the data that's at issue. And now the remediation step is basically use the examiner going through and removing or deleting this data from the person's devices and accounts. And what this remediation description is just doing is just saying, here's how the examiner is going to remove this data from this person's accounts and devices so that they no longer have access to it and that it can't be recovered. So this is where they're relying on you as the forensic expert to basically ensure that this data is no longer in possession of the person who's not supposed to have access to it. And again, just like everything else in this can be defined very generally, where you just define, okay, here's the general process we're going to use to take it, or you could be extremely explicit and state exactly what you're going to do to erase this data. It just depends on the case. It depends on the circumstances. And this is where you kind of have to decide how to define that. Sometimes the attorneys want it to be very specific. It just depends on the case. And I'll tell you, in cases like this, the remediation is sometimes the hardest part because you might have a case that's really easy where maybe the person only has a few documents in Google Drive, and that's a 5-minute process. You just go in, you delete the stuff, and you're in and out, no problem, in a few minutes. But sometimes you have cases where, for whatever reason, that person may have thousands of photos on their phone that's related to their previous work history. Now you have to go through the data on the phone and manually delete those images. Or maybe they have hundreds of emails in their Gmail account that's related to their former employer, and you have to go through and manually delete all those emails. Same thing with something like Google Drive. They may have thousands of documents scattered through their Google Drive account that you've identified, and now you have to go through that Google Drive account and just systematically remove and delete all of those files. There's not really a whole lot of magic behind this process, this remediation. It's just sort of, sometimes it's just brute forcing your way through it. And it could be, I've definitely had cases in my past where this remediation step spanned, a few dozen devices and accounts and took several weeks to complete. Dozens of hours to get through because there's just so much data. So this section really just identifies and states the process through which you're going to use to do that remediation. And then finally, the last bits and pieces here are going to be, sometimes the protocol may state that you're going to write a report. That's pretty straightforward. You're just going to write a report that states what you did and attest to any final results that need to be attested to for both parties, usually saying, yes, I confirm I securely deleted the data at issue from these devices and accounts, that sort of thing. Not always required, but sometimes it is just so that both parties have like something they can enter into the record from you. Sometimes it's a one-page memo, a one-page affidavit. Sometimes it's a full-blown forensic report. Just depends on the situation. Um, and then lastly, you'll have once everything is once the protocol is mostly finished, you'll then have some process defined here under which the examiner will actually remove any of the original data they collected that's a part of this case as well. So there could be some kind of retention period that they want you to hang on to. They may just say, hey, you now need to destroy any of this data in your possession within a certain time frame after the completion of the protocol, that sort of thing. Confidentiality, this is pretty standard language, just saying you're not going to reveal anything about the data to anybody else outside the case that you're not supposed to. And then this is one that I don't see this in a lot of protocols, but I like to add language like this in most of the protocols I put together. It's what I call the good faith clause. And what it means is it's just stating that sometimes there are issues in the forensic process that just have to be, there's no clear answer to how to solve them. You just need like everyone to have a little grace in the process and help you work through it. So there's issues like, hey, this phone, we're trying to extract it, but it's not cooperating. We want to try some different stuff here to see if we can get the phone data off of it, or there's something weird about some data set that you're working with. It's not working the way you want. You want to maybe collect it in a different way. There's also issues where maybe the person who owns these devices, they, for whatever reason, one of the accounts or devices they're having trouble accessing or something like that. So there's all these little things that can come up where you just need both sides to have a little bit of flexibility to help you get this protocol completed. So adding this clause here just kind of puts everybody in the mindset of like, hey, we're going to do our best, but if we run into a problem, we want everybody to kind of help us figure it out. We don't want to be, tightly locked to these specific things that we've said in the protocol. We want to have the opportunity to, bring up issues and discuss them and work through them. We don't want this to be a one and done thing where we have no flexibility. We can't make any decisions. We want to have, and even potentially have some iteration as well, where if the data or the accounts or devices we're working with aren't cooperating, we want to be able to iterate on different parts of the process. And then costs and modifications. So costs, just saying who's getting paid and who's going to pay it. That's pretty straightforward. And then lastly, modification. This is just saying like, hey, if there's any issues and we need to update the protocol or make changes to it based on new information, this clause, basically states here's what we can do. We can make that decision and we can go through these different processes to update the protocol or create a new one or supplemental or something like that. So all this stuff is pretty straightforward. Like I said, this template is like kind of a kitchen sink template. It's kind of listing anything and everything. You definitely don't need all this stuff, but this is a good baseline to use. And then you can use something like this to just modify it to your needs. And just in general, in conclusion, like I said, forensic protocols aren't used for everything, but depending on what kind of forensic work you're doing, these can be really helpful in just outlining the procedures you're going to use and giving everybody in a case, basically a roadmap to follow when you're doing whenever you do these complicated digital forensic workflows. This can really add a lot of structure to it and kind of help everybody. It just kind of helps everybody understand what you're going to do, what the process is, and gives everybody a roadmap to follow. So if you're not in the private sector, if you're considering a job in the private sector, this is something you may come across pretty often, depending on the type of work you do in the private sector. I honestly don't know if you're in law enforcement. Have you ever done anything like this before? If you're on the call, please feel free to tell us about it. In my experience, when I've done criminal work, I've never seen a forensic protocol in criminal work, but maybe it's out there. Maybe you guys are doing it. I'm not really sure. But this is, in my experience, has been mostly related to civil litigation. So I'll end it there and then see if we pass it over to Megan and see if we have any questions or Q&A that's come up since it started.
Alrighty, thanks, Matt. No Q&A yet, but if anybody who's on the call has questions, if you'd like to come on microphone and ask your question live, go ahead and raise your hand and I'll give you permission to turn your microphone on and you can ask live. Otherwise, if you're more comfortable asking a question in the chat, go ahead and put your question in the chat and we'll get it answered for you.
Yep, we will share the example.
And we do have a
Um,
raised hand from Cody. Cody, give me a second. I'm going to give you permission to talk.
Hey, Matt, can you hear me?
yep, yep, you're live.
Oh, perfect. Hey, two things. You had noted an affidavit of all of the the person attesting to their accounts. Is this something you'd share? I'd love to see what you have in your affidavit, if possible. And then
Uh, yeah. Oh, go ahead. Sorry.
what's your experience, when you're trying to work with the other party on like two-factor authentication? Sometimes it should be straightforward, but what's your experience when they want to make it a big drawn-out deal with everybody has counsel present for that? Because God forbid they say two things to you that they don't want to accidentally say. Um, do you
Yeah.
try to spell that out in your protocol ahead of time, or what's your thoughts or suggestions there?
Yeah, I actually think that's a great idea. If you know that these cloud accounts are going to be in the mix, I would say absolutely include some language in there, and just say, hey, we're going to, because there is a section here in this basic template that talks about passwords and stuff like that that need to be provided. Yeah, so like right here, actually, let me share my screen so you actually see what I'm pointing at. So like this part of the protocol right here, list all credentials, passwords, passphrases, two-factor methods, and encryption keys, but it doesn't necessarily state like the actual process for that. Um, so it could be something that you either state in the protocol directly, like, hey, this is how we're going to handle two-factor access, or you can, if you're having live discussions with them, you can bring it up. In my experience, I have had that where, we're trying to collect a Google account and we need the person's two-factor to do it. A lot of time, yes, sometimes the person will just have one of the attorneys present on the Zoom call because they don't want any. And I've even had this happen with clients that have hired me, where I'm working for the client, and the attorney doesn't want me to have any independent conversations with their client. So they'll like just basically the way I do it, I scheduled a Zoom call, invited the attorney and the client to it, and then we all hop in the call and we just execute the MFA process to get access to the Google account. In my experience, there's really nothing you can do. It's like that has to happen in order to get access to the account. So if the attorney wants to be present, then great, just get it done. But um, sometimes it is a pain in the ass because the client sometimes doesn't understand how we need to access it, and it can be a little bit of a tricky conversation, right? Where you basically just have to tell them, hey, look, there's really no fancy way to do this. We just have to log into your account to do a Google takeout or whatever, or we have to log into your email account to do some kind of email collection process. But like I said, with the protocol, you can outline that stuff directly if you want. You can add a lot more detail to it. I mean, and basically be as specific as
Yeah.
you want. But I don't have any good advice for you other than just be as nice as possible and just be as frank with them about what the process has to be. And there's just not any other option or choice to do it. In terms of the affidavit, I don't know if I have I know I've got some that I've done before in cases. I don't have a template for the affidavit though. At the
Okay.
end, it's
I
usually,
just use like a list your account and then, whatever. I wasn't sure if you actually had, because it said affidavit, so I wasn't sure what you had there. And
yeah,
I want to steal from people. So,
yeah, for their affidavit, honestly, I don't think they will do a full-blown affidavit.
okay.
It depends. I think if the case is like really adversarial and if it's kind of a knife fight between the attorneys, they probably will do it because they want it on record that this is what the person told us they had in case they didn't include everything or something. But usually it's more like a conference where either you're going to talk with them or you just tell them like, hey, you need to give us a list of devices and accounts that are even remotely related to this process, and they'll just provide that list.
Okay.
Whether it's an affidavit or not, probably won't be an affidavit. Like I said, this template here is it's just like a
Catch all.
worst case scenario catch all, and then you basically just whittle it down to the stuff you want.
Okay. And then just a thought on the, for use on the law enforcement side or criminal side, just for those who may be in the same boat, I recently used that to make all parties comfortable. We called it a protective order essentially, but it was the same thing,
Yeah.
and just made the DA's office feel comfortable sending us original evidence that they didn't collect, so we could go in and look for some data. And once we got that in place, everybody was really comfortable with sharing that. So it's essentially the same thing, but for those who might be trying to get their hands on something, it can definitely make it easier.
Yeah, exactly. I think it's one of those things where it's a little extra work, but just like Cody said, it just helps grease the wheels a lot because it takes a lot of the mystery out of what you're trying to do, and it gets everybody, just gets everybody on the same page basically. And also it makes them, part of what makes them feel better is that they now have something they can hold you accountable for. So like I said, if you color outside the lines of that protocol, they can basically they can just call you out on it and potentially use it against you or use it against the other party in court if they need to. So it just kind of, you're doing sensitive work, and it just puts you in a place where you're like, okay, I'm laying out what I'm going to do here. The thing you want to be careful of though is if you're a defense expert, you don't necessarily want to lay out your entire strategy in the protocol, right? You want to just kind of define the basic process you're going to take, but you may not necessarily want to say, hey, here's what we're looking for. Here's exactly what we're going to do. You just want to lay out exactly how you're going to access the evidence and how you're going to do your analysis, and kind of give yourself some privacy around what you're targeting as far as your findings are concerned. But thanks, thanks Cody, thanks for joining. Also, Cody's a longtime friend and colleague of mine. We've known each other for years, and he's very experienced in this stuff. So maybe one day I'll convince him to come do a presentation on here at some point.
Start asking early.
Yeah,
100%, man.
Right. Cool. All right. Does anybody? It's everybody asking. Yes, we're going to share the templates so that everybody has access to it. And I would highly recommend if you use this template, please edit it, whittle it down a little bit. Like I said, it has a lot of stuff in there you probably don't need in most cases, but it's just there so that you have something to work with. I wonder if I can take. Do you know, Megan, if I can share it in this webinar directly?
I think you can as a host. If not, we'll include it both in the email that we send out with the recording, and we'll put a link to it from the description field in the YouTube recording once it's posted there.
To hosts and panelists. Let me see. Let me do everyone. Okay. Everybody, if you check the chat, you should. I just dropped it into the chat, so you should see it there now.
Does anybody else have questions or thoughts they want to share? We'll leave this open for another minute so people can download that file.
Also, one thing I'll suggest, one last bit of advice too. If you have access to ChatGPT or Claude, this is the sort of thing that they are really good at. So I wouldn't necessarily put client details or anything into it, but you can take something like this protocol, feed it into ChatGPT or Claude, and give it some specific parameters and be like, hey, can you rework this, whittle it down to just these concepts, and it will create, another document for you that's very well crafted, very well worded, and kind of has stuff for you, so you don't have to necessarily bang out this entire thing on your own. And then just use it to quickly get the rough draft, and then just do the fine tuning and review afterwards. So this is the sort of crap that these LLM models are really good at. But just the caveat I always say when using these LLMs, just be very careful about like entering client data and things like that into it.
Okay,
all right, cool.
I think that's it for questions. So we'll go ahead and wrap up. Thanks everybody for joining today. And we hope we see you in 2 weeks at the next one.
Cool. Awesome. Thanks, everybody.